The Kaduna State government has given conditions for granting Ibraheem El-Zakzaky and his wife Zeenat a medical leave. Do they have the right to give such? And also the Federal High Court in Abuja has put a stop to moves by the National Assembly to take over the affairs of the Edo State House of Assembly. This is Plus Politics, and I am Maryann Okon. The Kaduna State government has given new conditions for granting the embattled leader of the Islamic Movement in Nigeria, Maryann, also known as Shiite, Ibraheem El-Zakzaky, and his wife Zeenat, permission to travel to India for medical treatment. Now, the Kaduna High Court, presided over by Justice Dairus Kobo, had earlier permitted the Maryann leader and his wife a leave to travel to India for treatment following injuries that they sustained during the Maryann clash with the Nigerian army on December 15, 2015. The court, according to the Prosecution Counsel and State Director of Public Prosecution, Dari Bayero, El-Zakzaky and Zeenat, his wife, must not go to any other hospital other than the ones they specifically requested for. According to the statement, the conditions to be met before the embattled Shiite leader and wife could travel. Now, joining me in the studio to have this conversation is a lawyer, and he's one of our very interesting guests. I'm talking about Mr. Steve Aguirre. It's good to have you join us. But before we get into the conversation, we'll take a short break, and when we come back, we'll get into the conversation in earnest. Stay with us. Well, welcome back to the show. It's Plus Politics, and I'm being joined by my guest as we look at the El-Zakzaky issue. I would like to introduce Dikbo Olayoku. He's a journalist, and of course Steve Aguirre, legal practitioner. Thank you, gentlemen, for joining us. So, of course, the Federal High Court has, the court in Kaduna has said they're granting leave to El-Zakzaky and his wife Zeenat to go for a leave in India to get medical care. But of course, there has also been conditions listed by the Kaduna State government. I'm going to start with you, Steve, because you're a legal practitioner, and I'm wondering, in terms of diplomacy, because they're not going to Eko Hospital to get medical treatment from Kaduna State. They are going to a different country that has a different set of rules and laws. And I'm wondering, can Nigeria give conditions as to how a person is being treated in India? Is there any such provisions in the Constitution?
I consider what Kaduna State government is doing as a bit, first of all, it's extrajudicial. The fact is that the court has already given the orders it will give. The judicial powers of Nigeria are in Section 6 of the Constitution. The courts, all individuals are bound to obey courts. The courts have given their own condition, and what the government of Kaduna State is doing is, in effect, overruling the conditions given by the courts. Now, secondly, there is no obligation on India to obey any of those provisions. Relationship between countries is governed by international law and then treaties and all that. And there's no obligation. I mean, they didn't. Our courts did not seek their opinion before granting bail to him, and so they are not obliged by any of the conditions that.
So, for India now, if El-Zakzaky is coming to their country, he's coming as a medical tourist, not as a prisoner of any sort or a terrorist, is he?
The authority of our courts, in general, and here
within the confines of the country.
The Kaduna State government's authority ends within the confines of its state. So, if you look at some of the conditions, they even appear to be giving the federal government responsibility. The government should do. So, I mean, you have an anomalous situation where a part is, the tail is wagging the dog. A part is seeming to control the whole. So I don't know where the Kaduna State government is coming from. But it follows from a pattern which is emerging. The other time, one of the ministerial candidates was saying in the National Assembly that government is not bound by orders of courts if they think that national security will be affected. I think this is a pattern in a mistaken direction by elected officials who feel that they are above the law.
I'll move to you. I remember it was the NBA's event where Mr. President showed up and said that national security can be placed above the rule of law. And I remember the uproar that, you know, it kind of conjured. Could this be what is playing out today? And in terms, when we talk about national security here, what does that really entail in Mr. President's context, if you have any idea?
Yes, you see, unfortunately, issues in Nigeria are always wrapped with the flag of politics. I deliberately use the word of flag because flag belongs to a country. And the issue of national security has been settled by the Supreme Court in the case of Asari Dokubo versus the state, where the highest court in the land specifically made a categorical statement that national security can be subsumed, individual liberty can be subsumed under the issue of national security. But the question is, who determines national security? What the judgment refers to is that if we want to do it, bring the matter to us, then based on the facts on the table, we can now say, okay, on the basis of this, just like the judgment that we had today from Justice Taiwo, we made reference on the basis of Section 27 or so and so. So I think that is where the contentions are really coming from. Who determines when to keep somebody in perpetuity in the name of national security? So it is not in contention. That's it. Even if we look at the constitution that is guiding our operations, from Section 30, 32 to 44, you will notice that it, like I always say, it gives you so many freedoms. But when you get to Section 45, all these freedoms can be abridged by certain factors, but some steps must be taken. So I think, like I said, the issue of Nigeria is that everything is taken from the politics perspective. And that is why issues that should not even, because Nigeria as a country has more pressing issues that we allow some trivial matters to occupy the front burner.
Is it we who allow it, or the political gladiators, as we call them?
Exactly, and unfortunately, we keep
clogging the airwaves and the newspapers with these stories and diverting attention to them.
Unfortunately, we as a people key in. We tag along, and they are sitting somewhere laughing, enjoying it, because, like you rightly said, they have created a distraction that would be chewing until they just wake up another morning and say, this one is also becoming stale. It's almost becoming stale. Let's throw something again at them, and we begin to discuss it. Whether there are serious issues that should have taken the attention of about 200 million Nigerians, if you go by the estimates that they gave us. So I think, yes, we need to appeal to our political gladiators, as you call them, but they are doing this because they know the level of awareness, or let me say the level of education of the people they are dealing with. And that is why they get away with some of these things.
So I also want to emphasize, Asari Dokubo versus FRN, the facts are this, that Asari Dokubo applied for bail. Asari Dokubo made some threatening pronouncements. He formed a group and he threatened to take over some parts of Nigeria. He was charged to court for treason, amongst other things. Then he applied for bail. These are the facts. Now, decisions of any court, including Supreme Court, relate to the facts of the matter, and they apply only to the facts of the matter. So, if you read the case carefully, you will find that the discussion about national security was what I would say, what we call obiter, in that they veered off the main issue.
So you're saying it's not necessarily the crux of the matter. It wasn't a determining factor.
What they were determining was a bail application.
If what you just said is anything to go by, In Asarido Kuba's case, he made threatening statements that also wanted to lay claim to certain parts of the country.
Exactly.
In this case, we haven't heard any claims per se from the IMN leader, apart from the fact that they had a face-off with the army.
Yes. Yeah.
They have not asked for secession or anything. They just have...
I may be wrong, but I know for one that the charges he's facing right now are not even treason. I understand it's murder. So the facts are different.
So where does national security come into play? Now,
national security does not entitle you to, one, hold on to somebody without granting him bail.
Even in the case of terrorists, and I'm not in any way saying that El-Zakzaky is a terrorist, because there's nothing that categorizes him in that light.
You have to go to court, and even I know that a lot of attempts are being made now to take people to court based on this terrorism legislation, and what we call ex parte procedures are being used, which means the government goes to court without allowing the other side to respond to the affidavit and all that. I think it's an issue that will be revisited, because the Constitution provides fundamentally that if you take me to court, I must be heard, particularly in a matter that is criminal. I think there's a trend now in 3 or 4 cases where government goes to court in respect of terrorism matters in an ex parte manner, in a manner in which the other side is not allowed to state its own side. You have to ask, can this trend of decisions not be challenged on fair hearing grounds?
Especially if we find ourselves in a democracy. And coming back to you, sir, on the issue of trends, we've seen government hold certain people beyond 48 hours that they should hold. And in the case of Showore, we've seen another court saying that he will be held for another 45 days until investigation.
Decision delivered ex parte.
Exactly. So is this not something that maybe the NBA or the average Nigerian should... I don't know if the average Nigerian understands what an ex parte is, so hence the NBA and people who are legally inclined, should they not be challenging this move that has become somewhat of a trend by the government?
But I think, well, there's no harm in challenging it. But the question is, all these laws are things that have passed through legislative scrutiny and processes. The Terrorism Act that we're talking about came up under the former President Jonathan, and it was sent to the National Assembly that were expected to have represented the people. Again, if you look at Section 35 of the Constitution, subsection 4A and 4B, 35 talked about somebody's arrested, you must talk to him in the language he will understand. He has the right to refuse to talk until he has his lawyer, and that you must take him to court within 24 hours. But if it is not within the premises of where there's a court, you can go for it. But if you go to Section 35, 4A and 4B, it looks at perhaps there will be a situation where the investigator, because it even said that you can arrest somebody to prevent him from committing a crime if you have reasonable ground to believe that he was going to commit a crime. Now, arising from you must take him to court, that section says you can go to court to ask for either 60 days or 90 days. I'm not talking of Terrorism Act upon which Showore has been detained for 45 days. He's going to be detained rather, because that is exactly what the Act says. But even the Constitution, that is the ground norm, that will have said the Terrorism Act has flouted an aspect of the Constitution, and it says where a law runs contrary to the Constitution shall become supreme. It even states that you can go either 60 days, that's Section 4A, or 90 days, but it must be with the consent of the court. So that is why when we are talking about these rights and freedom, there's a need for us to understand that there's no absolute freedom everywhere, anywhere. And that is why the Constitution says in case there is a reason for you to delay to detain somebody for more than the specified 48 hours, you must go to court. and you must have a reason why the court, and if, like the judge told us today in the judgment, that is why, unfortunately, when our journalists these days report stories, they don't go into the details that will educate their listeners. And that is why a lot of Nigerians, the moment they listen to the headlines, they begin to run along with it. And that is why a lot of misinformation in the society. The judge today said that having watched the video, which happens to be the evidence, submitted, attached by the DSS to their plea, that he will have no obligation but to grant that request. It is in the law. So I think where the NBA would have been very active was in the process of making this law. Where were they when this thing was in the National Assembly? Did they go to bed? Where is it that nobody has said, okay, this Terrorism Act was passed, I think in 2015 or 16. Where have they been since then? Nobody has gone to say, okay, are this thing trampled on the fundamental rights
of the average person?
Maybe a judge would declare that aspect null and void, but not when it has become operational. Now we now begin to say, oh, so this thing is there.
Okay. Let me just make the point.
You want to make a case for the NBA now?
Yeah, no. First of all, if you are arrested, you must be taken to court within a reasonable time. Actually, the maximum time you must be taken is 48 hours, not beyond. Then secondly, actually it's not for the NBA to do anything about it as it stands now. It's for Sowore himself. These orders were obtained without hearing him. So I expect him to appeal against these orders to the Court of Appeal. Then he would put before them the issue. Was it right for this matter to be heard without serving me, having regard to the provisions of fair hearing in the Constitution? Was it right? You are holding me. I'm with you. There's no emergency. It's not that it was difficult to inform me so that I can inform my lawyer to also file a counter affidavit. Was it right to determine this based just on the affidavit of government? Because the fair hearing provisions in the Constitution, as Esho said in one case, they are not constitutional creations. They existed before the Constitution. It's often said that when God was to punish Adam, he first of all asked Adam, what have you done? God did not just issue sentence. He heard from Adam. So So
you're categorizing fair hearing as also like a fundamental human right?
No, it is. It is actually a fundamental human right. And as Justice Esho has said in one case, in the case of Ransom Kuti versus the Attorney General, fundamental human rights are above the ordinary laws of the land. It's a 1985 case. And Esho is one of our greatest judges. So what we are dealing with now is almost a natural right. I mean, even in our villages, if I come to report you, the first thing the elder does is, where is he? Let me hear from him. I mean, it's not only common sense, it's part of our tradition, and it is enshrined in the Constitution too.
Okay. Sorry, Barrister, maybe can we look at it from this perspective?
Yes.
As of today, Sowore is not on trial.
Yes.
He has not been taken to court.
Not at all.
No.
What is happening is somebody was about to commit a crime, and then you arrested him and detained him. What is the essence of detention? To make sure that he doesn't carry out that criminal act, and then to prepare him for trial. Normally, it's supposed to be released within 24 hours. But maybe because those who drafted this thing are aware that maybe it is not possible for us within 4 days to have concluded our investigation. Maybe if we release this guy, I am just playing the devil's advocate. This is a guy that has dual citizenship. The tendency is there that he will follow Nadeko route and escape. Therefore, the issue of justice has vamoosed from us. That is the issue. As of today, Shiwori has not been taken to court. So maybe that is why the judge is looking at the issue of fair hearing, is to come and tell us, oh, I am not guilty. But as of today, the issue of guilty or not guilty has not arisen.
It hasn't come up.
No.
It is, okay, we have to detain you to make sure you don't commit an offense, to make sure you don't run away.
No. Okay. I think what you are missing here is, first of all, there's a constitutional presumption of innocence. So as we are sitting here, if the police come to arrest us, first of all, we are presumed innocent. We must presume that Shiwori is innocent.
Yes, of course.
So now you take him, you have arrested him now. He's presumed innocent. Then he has to wait for you to investigate the crime for which you are arresting him. How fair does that sound? I arrest you first, then I look for your crime. But these are things that I'm sure he will.
I don't want us to dwell on the Shiwori issue. I don't want us to dwell on the Shiwori issue. I want us to come back to the El-Zakzaky issue.
Yes.
Because we're looking at the conditions again that the Kaduna State government has given.
Yes.
And some of them are really preposterous. And they're also asking El-Zakzaky to sign some form of undertaking before he leaves. And they're saying they should not allow him to take asylum and things like that. And he must not go to any other hospital other than the hospital that has been, or they had requested for. So take, for example, he's being treated not just for his health, but we hear he's lost sight on one of his eyes, and the second eye is getting bad. So if he's being referred to a specialist eye hospital or an optician in another specialist clinic, he's not allowed to go?
You have to understand that what the judge pronounced on that day was not a bail. Some people get it confused.
He said, no, it was leave for medical treatment.
Maybe there's need for you to understand that as far back as May 2018, El-Zakzaky applied for bail to the same court, and it was rejected until this issue of medical tourism came in. And you have to look and read the judgment very well. The judgment said that he is releasing him for medical attention. He even was...
And does that medical attention not apply? My question again, he has been told categorically in those conditions that he cannot leave that hospital to any other hospital.
Even the judge himself mentioned the hospital, because that was one of the documents they submitted.
And my question is, if that hospital is just to pay attention to whatever ailment his body is facing, and then there is another eye clinic that he's being referred to for his sight, can he not go? So what's the essence of going to get a medical...
Because the ruling was categorical about the hospital. You don't forget that they
submitted... What's the essence of going for a medical treatment?
Don't forget that they submitted medical reports from government doctor and private doctors, at least his own private physician. They submitted letter of invitation from the hospital. And the judge made a categorical statement that this is the hospital you are going. And that the guy didn't release him on bail. Go for medical attention. Come back immediately for your trial to continue. The judgment is very clear. So listen. If you look at the conditions given by the Kaduna State government, don't tell me there's anyone that contravenes that judgment by the court. Any of them.
Can I?
We have just 2 minutes. No, I want to ask a question and then you can answer him.
Yeah.
What if, I'm not saying this is what's going to happen. Let's just preempt India. Like he said, I'm going to play the devil's advocate. And the Indian government feel that he somewhat applies for that same thing that the government is saying and says he wants to take asylum in India. Do you think that the Indian government would say no to it?
Okay. Let me sidestep your question first and focus on the first thing he has done. You see, in a court case, there are 2 parties. So the Kaduna State government is a party in the case against El-Zakzaky. In fact, they are the prosecutors.
Yes.
Criminal law is prosecuted
they took him to court.
in the state by the states. So what is happening right now is, for instance, I take him to court. The court gives an order that is maybe favorable to me. Then I go out, because the Kaduna State is effectively a party. Yes. I go out and start dictating what the court order means. I mean, that doesn't make sense. I cannot add one word to what the court has said. I cannot remove one word. In fact, if I start to make such a statement, it's just a waste of time.
Okay, quickly.
The court order is what matters.
What happens if El-Zakzaky breaches any one of those conditions or whatever it is?
He can breach all the conditions of the Kaduna State government. What he cannot breach is the conditions given by the courts.
And that's what I'm asking. Yeah. If he fails to return, what can the government do?
The court order does not say he should not return. The court order does not allow him to. The order says go and take medical treatment. The assumption he will come back.
And if he does seek asylum?
If he does seek
asylum.
If he does seek asylum, well.
I guess that's a good response. Well, I want to say thank you to you, Dikwa Olayoku, journalist, and Steve Agede, legal practitioner. They're not going anywhere. We'll take a short break, and when we return, we'll be speaking on the battle over the Edo State Assembly. Stay with us. We'll be right back.